Now, up until this point, the type of rights that we have been discussing are in relation to the economic rights. Basically, what form of financial benefit that a copyright owner would be entitled to in relation to his work. What needs to be understood from this point onwards, however, where we discuss moral rights, is that these two types of rights, namely economic and moral, exist exclusively of one another. Therefore, moral rights belongs to the owner of the work and exists independently of the economic rights, and the author can enjoy moral rights even without having those economic rights. What is meant by this is that, firstly, the right to have his name indicated prominently, the right to use a pseudonym in place of his name where he so wishes to do so, the right to object to any distortion or modification, reproduction, and so forth. Pasterfield and Denham has noted quite eloquently that distortion must result in prejudicing the honor or reputation of the author, because mere aggrievement, according to Pasterfield and their lordships, is insufficient. From this point onwards, what we need to identify is, firstly, what amounts to a substantial part of the work. This becomes quite important in relation to reproduction of the work. There might be situations in which something might amount to merely fair use, something that we will be looking at a bit later on. But firstly, if it is worth copying, as per University of London Press and the University Tutorial Press, it is worth protecting. On the other hand, a seminal case, which is Ladbroke and William Hill, notes that it depends on the quality, then the quantity of what was taken. In essence, it might simply be one or two elements of the actual work, but if the spirit of the entire work can be seen even in that small reproduction, it may amount to a usurpation, or it may amount to an unlawful usurpation of the moral rights of the author. Having discussed the different types of rights, namely economic and moral, there are a certain set of limitations which have been imposed on these copyright laws as well. Firstly, they might be limited by specified periods of time. This might generally be assumed by virtue of the type or the subject matter of the type of right that we are discussing, or the copyright law itself in a particular country, or it might be specified by the author or authors themselves. The rights themselves may be waived by the author. It's completely up to the author or the owner of the rights to waive whatever rights that he has. There might be no infringement if the act itself is authorized by the owner. Hence why in any reproduction or any cover, for example, of a song, where the artist will reconcile any issues that he or she might have with the owner by actually discussing prior. There is no copyright protection for works which are obscene, immoral, defamatory, and contrary to public policy, irrespective of the general premise that copyright law is automatically imposed without registration. Stevens and Avery is a seminal case which outlines these limitations. Apart from these various notions or characteristics of copyright law and the rights that ensue from that point onwards that we have looked at thus far, there is the component of fair use. Now, fair use can be succinctly surmised as work which entails perhaps criticism, comment, reporting, or teaching in relation to the original work. In essence, it is impossible to define, as per Lord Denning in Hubbard and Wasper, but it becomes, again, much like many other aspects of copyright law, a question of degree and the characteristic and the spirit in which such reproduction of the use has been done so. Having said that, Hyde Park residents and Yelland have outlined that fairness in itself must be something which is judged objectively, in essence, in the perspective of the reasonable man, the man on the omnipresent Clapham omnibus. Therefore, when we consider acts of fair use, a number of different aspects come to mind. On the one hand, whether it was a private reproduction, whether it was done for purely private purposes, whether it amounted only to, for instance, quotations, whether you were quoting someone, for personal purposes only, again utilizing the original, whether it was a cover performance, whether it related to current affairs and or information, whether it was stored for the purposes of libraries or archives, or more likely, whether it was for educational or academic purposes. Collectively, however, once we consider the ownership of copyright and the fact that we considered earlier as well that economic and moral rights can exist independent of one another, and the author can still have moral rights irrespective of relinquishing his economic rights, a few areas which might be relevant in understanding the position of economic rights as opposed to moral rights can be seen in this last segment of copyright law. So on the one hand, as we discussed previously, the moral rights of an owner can remain irrespective of economic rights. However, the economic rights of the author or the owner of the original work may differ based on the context in which the work was actually created. So for instance, on the one hand, if you had a situation where you were an individual author, someone who proactively created something, the economic rights will remain with the author. Conversely, if you worked with another person or if you jointly created a particular type of work, then co-owners will exist unless the parts of this particular creation is severable. For instance, in a music album, in a particular series of songs, few songs might have been co-authored with another party, in which case there will be co-owners to the rights towards that song. On the other hand, you might have collective works, where you have situations in which there were multitudes of people, not just 2 or 3, but multiple number of people. The same rule as that applies to joint authorship will apply there as well. A more interesting situation arises when a work has been either commissioned or created by employees while they were in the course of their employment. So on the one hand, if it was created while in the course of employment, the economic rights will automatically accrue towards the employer unless the benefit that was accrued from such works went far beyond that which was anticipated by either party. On the other hand, there might be situations in which third parties are commissioned to do certain works, in which case the economic rights will belong to the person who commissioned the work, once again, as long as it falls within the reasonable ambit of the economic benefit, the amount of the economic benefit that both parties were acquiescent of. When it comes to audio-visual work, for instance, it belongs to the producer of the work itself, for instance, a film, unless contracted otherwise. That was an overview of copyright law. We considered what amounts to a work, what amounts to things which are protected and things which are not, the mechanism by which protection occurs, and in this lesson we rounded out our entire lesson on copyright by considering both economic and moral rights and how they exist independently to one another, and finally where those economic rights lay based on the context in which the work was created. In the next lesson, we move on to another area of intellectual property, which is industrial design. Thanks a lot for watching this video. Click on a subject of interest to learn more.